So that brings me to the fourth area. What particular fields of law have been occupying my time? Let me suggest first what I'd call the law of September 11th. The law of September 11th really began on September 11th, 2001. And the question is how to formulate policies that get back to both consistency with our values, our international obligations, and to our national interests. In many senses, we have been tasked with unwinding practices that we would not have authorized had we been in office when they were first encountered. And the progress on this is hard slogging. Well, we all know it's a week after a snowstorm. It takes a lot longer to dig out of a snowstorm than it does for it to snow in the first place. And you can look at it two ways. A week after the snowstorm, why is there still snow on the ground? Or is there a path emerging which we can follow? Now, what has the president tried to do with regard to 9/11? He issued on his second day in office 3 executive orders to launch processes of review of the interrogation and transfer process. A task force issued a report. He has had an interagency group examining all of the cases, the individual detention cases on Guantanamo. Another group has been looking at questions of detention policy. He has committed himself firmly to the closure of Guantanamo. Dan Fried has been appointed ambassador for the closure of Guantanamo, has been working on this issue. Detainees are moving out every day. The president directed that Guantanamo be investigated to determine that it complies with Common Article 3 of the Geneva Conventions, that all future detentions and interrogations be conducted consistently with the Army Field Manual, a task force recommendation making this policy permanent, the task force itself issuing a set of recommendations to ensure that individuals who are transferred are not transferred to situations where they would face torture. The Military Commissions Act was revised and amended, the biggest change being to bar the admissibility into evidence of statements taken as a result of cruel, inhuman, or degrading treatment. We have established more robust review procedures for detainees in Afghanistan. They can now challenge the evidence on which detention is based. They have the assistance of personal representatives. The Justice Department has revised the state secrets privilege to give a better balance between open government and national security. The U.S. has become a party to the Convention on Certain Conventional Weapons as of January 21st of last year, reaffirming our commitment to the development of international humanitarian law. And there are many other steps in the works and to come. Now, is this the end? No. But I do not consider these to be insignificant achievements, nor do I consider them to be the status quo ante. It takes a lot longer to dig out of a snowstorm than it is to have a snowstorm, but we are on our way. Now, a second area, besides the law of 9/11, is the whole area of international justice and dispute resolution. We are addressing these in a variety of settings. This past November, for the first time, we attended the International Criminal Court Assembly of State Party meetings. We're planning to attend the intersessional meeting in the United Nations in March, en route to the review conference for the ICC in Kampala in 2010. We have supported particular prosecutions at the International Criminal Court, and we've worked to support accountability before various ad hoc tribunals, the Yugoslav Tribunal, Sierra Leone, Lebanon, etc. In the business setting, we've worked on questions of the Iran-U.S. Claims Tribunal, now in its third decade, the UN Compensation Commission, the NAFTA tribunals, and we've taken positions in a number of domestic litigations, most recently the brief that we filed along the FG's office in the Samantar case, which will be argued on March 3rd. Now, I think there's been a pattern over time. John Bellinger noted this when he was himself legal advisor of the Justice and State Departments taking positions in many cases involving foreign policy issues, but not necessarily a novel or significant foreign policy interests of the United States. Just to remind you, back in 1964 in the Sabatino case, the Supreme Court famously said, often the State Department will wish to refrain from taking an official position, particularly at a moment that would be dictated by the development of private litigation, or which might be inopportune diplomatically. In other words, the fact that a private case raises a particular set of international law issues doesn't necessarily mean that the U.S. government ought to intervene. Over the last few years, the sheer number of requests from courts and parties for statements of interest has expanded. This raises serious resource considerations, not just for us, but for our clients in trying to work out the policy implications of a particular brief. Therefore, ideally, we would wait until these matters reach the highest levels of the courts before participating. And I think that you should not then assume that just because your client has a particular case that has an international dimension, that the U.S. government needs to intervene, needs to appear as an amicus, or needs to make a statement. In many cases, the law or doctrine in the area is well settled and can be, in our view, correctly decided by the courts without participation by the State Department or the Justice Department. And we have filed a number of pleadings in which we simply say we will not participate, but no inference should be drawn from the decision not to participate. Now, I know every administration comes in over time, says they're not going to do as much of this as in the past, and then get drawn out over time. This is a sort of hydraulic effect. But I do think that as much as I've heard about the Tate letter, which of course was by a former associate dean of Yale Law School, the Bernstein letter, which was of course by Jack Tate, it was one of two Tate letters. At some point there may be a Koh letter, but it's not one that I'm rushing or looking for a vehicle to send forward. A third field of law in which we are working is in the area of international engagement, how to reach certain kinds of accords and agreements with other nations. And here we're operating in an unusual political environment. You all see the difficulty of getting 60 votes for health care. If you read the Constitution, you know you need 67 votes to get a treaty ratified. And it's a long way from 60 to 67. I know how the treaty feels. I got 65 votes for cloture. I got 62 votes for my confirmation. If I were a treaty, I wouldn't have made it. So I tell you, I know how a treaty feels. Nevertheless, there are many areas in which we have been able to do treaty making. Last year, the U.S. exchanged and deposited instruments of ratification on more treaties than any other year in U.S. history. Already this year, there has been one ratification, the French tax protocol. We're expecting the Senate to act on a number of other tax treaties, the Hague Child Support Treaty, the defense cooperation treaties with the UK and Australia. We're hoping for actions on various bilateral investment treaties, plant genetic resources treaties, etc. And we're considering a number of ways in which these international agreement processes can be moved forward. One area very much below the public radar screen at the moment is in the area of private international law. The Hague Convention on Choice of Courts will need to be implemented domestically following the Supreme Court's decision in Medellin. There are a number of proposals on the table for exactly how to do this, by statute, by an approach which some are calling cooperative federalism. This will be an important dimension of my time, I think, as legal advisor. A fourth area out of five is what I'd call the law of the State Department. This is where some of the most intricate and difficult lawyerly issues of our agency come to us. One area, of course, has been the dramatic expansion of contracting, consular issues, visa questions, restrictions on foreign assistance, diplomatic immunities. This body of law will continue to evolve.